Hello friends, in the series on the income tax cases, today we will discuss a very important case which is regarding the addition of the jewellery found in the premises of the assessee. The present case relates to the situation where the revenue got some jewellery in the search and seizure operations on the assessee and found that the jewellery found in the premises of the assessee is above the limits of jewellery which is given in circular number 1916 dated 11th May 1994. In the present case, the issue was that if the status of the assessee is such that his income tax return supports the holding of the jewellery by the assessee, so whether in that case the addition under 69A is justified. This issue has been taken up by Delhi ITAT bench in the case of Kirti Singh versus Assistant Commissioner of Income Tax. This case is reported in 108 ITR Tribunal, short notes, page number 71, and the date of the judgment is 7th December 2023. In the present case, there was a search on the assessee, and in that search, 2479 gram jewellery was found at the premises of the assessee. When the assessment proceedings were going on, the assessing officer accepted 1300 gram jewellery as attributable to different family members of the assessee. And at the same time, the assessing officer treated 1179 grams jewellery as unexplained. The assessing officer was also of the view that the jewellery out of 914 grams which were relatable to the assessee, the assessing officer accepted the jewellery up to 500 grams and for the balance he made the addition. When the addition was made and the assessee was show caused for this addition, the assessee explained that the some jewellery also relate to the sister-in-law of the assessee, but the assessing officer ignored the submissions of the assessee, and the assessing officer also ignored that the assessee is a high net worth client and the assessee has a high status which is also reflected from the income tax returns of the assessee. When the additions were made and the matter was before the CIT appeal, the CIT appeal also upheld the order of the assessing officer. When the matter was before the tribunal said that the para 3 of the circular number 1916 of 11th May 1994, that circular says that the status permit holding of higher jewellery by the assessee if the assessee is able to explain that jewellery. The tribunal said that in the present case, the assessee's explanation was plausible. The assessee explained and given the evidences that the remaining jewellery belongs to the sister-in-law, and the tribunal was also of the considered view that the circular number 1916 of 11th May 1994 does not say that any jewellery which is above the limits prescribed in the circular will be added into the income of the assessee. There is no presumption like that. So in the present case, where the assessee is filing the income tax returns which come in the higher income bracket, and the status of the assessee is like that the holding of the jewellery is very much justified with the income of the assessee, so the additions made on the basis of presumptions and conjectures is not justified. Friends, the crux of the case is that if any jewellery is found, but if that is not explainable, that will be added into the income of the assessee. The addition will not depend that whether this jewellery is below the limits prescribed in the circular. If the jewellery is less than the limits prescribed in the circular, but if the assessee is not able to give a plausible explanation, then that will be added into the income of the assessee. And conversely, if the assessee got some jewellery which is above than the limits prescribed in the circular, but if the assessee is in a position to explain that jewellery according to his income, even in that case, the addition on the basis of jewellery cannot be made. So the limits which are given in the circular just gives a yardstick that which jewellery can be seized from the assessee in search proceedings. That circular only gives the guidelines for the seizure of the jewelry. That guidelines does not give the directions to make the addition on the basis of the holding of jewelry. At the end of this video, once again I am repeating the name of the case. The name of the case is Kirti Singh versus Assistant Commissioner of Income Tax, and this case is reported in 108 ITR Tribunal, short note 71, and the matter has been decided by Delhi ITAT C bench on 7th December 2023. Thank you, friends.